So thanks for having me here to present my paper on Reconstructing Reconstruction-era rights. The paper takes on the conventional wisdom about the so-called trichotomy of rights in the Reconstruction era, this distinction among civil, political, and social rights. The trichotomy was critical to the court's reasoning in Plessy against Ferguson, and it's widely accepted among modern scholars that this trichotomy accurately reflects the meaning of the 14th Amendment and the privileges and immunities, the kinds of rights to which it doesn't extend, crucially, civil rights included, political rights, everyone agrees, excluded, and then social rights, whatever those are, excluded as well. What my paper shows is that at least if Section 1 of the 14th Amendment is written in legal language, which is more or less the claim of my recent book on the 14th Amendment, then the trichotomy does not make sense. It does not accurately reflect the distinctions among the types of rights that the antebellum legal thinkers adhered to. They adhered instead to two different dichotomies, which I guess together maybe make a separate trichotomy, but there is this distinction between civil and political rights on the one hand, and a distinction between private rights and public privileges on the other. This is actually widely recognized in other areas of law, but not in Comedy Clause jurisprudence, Article 4 jurisprudence. And so part of my project is to try to see the relevance of these two different dichotomies for Article 4. So what does all this matter first? And then I'll go through briefly the argument, because I think it helps us to answer two prominent questions, namely the correctness of Brown v. Board of Education and Loving against Virginia. If, as I claim, the Privileges or Immunities Clause of the 14th Amendment covers civil rights, then it covers marriage. Because marriage was not a political right and it was not a public privilege. So marriage is a civil right, and the point is it is at least covered by the amendment. The question then becomes whether laws prohibiting interracial marriages are part of a system of caste legislation intended to maintain white supremacy. I think the answer to that is quite obvious. All one has to do is look at what Chief Justice Taney said in Dred Scott. The fact that the laws prohibited interracial marriage was to him the key indicator of what he claimed was the degraded and inferior status of black persons. Loving v. Virginia, easy case. Brown v. Board, a bit harder. Public education was not a political right. So the question under my approach is whether the Privileges or Immunities Clause applies to public education because it applies to public privileges. If the clause does not extend to public privileges, then Brown was wrong. If it does, then the clause at least applies, and again, it becomes a question on the merits, whether separate is equal. So those are the stakes, and in my short time, I'll just assume for sake of argument what I've argued previously, and what I think many in this room have started to agree with, or already agree with, or already did agree with, which is that at a minimum, the Privileges or Immunities Clause of the 14th Amendment covers the same rights as Article 4 of the original Constitution, the Comedy Clause, the Privileges and Immunities Clause. And so then let me just go through briefly three propositions. First, about social rights in Article 4, second, about public privileges in Article 4, and thirdly, why we might think the Privileges or Immunities Clause treats public privileges differently than Article 4. Okay, so first, social rights. There is nothing, zero, absolutely nothing that I could find in antebellum Comedy Clause jurisprudence or other legal sources, even remotely identifying a category of social rights of the kind that supposedly is part of this Reconstruction era trichotomy. It was widely accepted that the Comedy Clause covered civil rights, which are essentially just natural rights as modified by the laws of civil society, and which all free governments must secure, and not political rights like voting or holding office. I canvassed dictionaries, treatises, cases, congressional records. I can't find anything. Social rights was used, and it was just another term for civil rights or for all the rights stipulated for in the social contract. Under any definition of social rights I could find in the antebellum period, civil rights are covered. They're the same thing. Okay, harder question, what about public privileges and Article 4? There is no case directly on point, but I think we have sort of three sources or sets of sources that suggest public privileges are not covered by Article 4, which might cause a problem for the 14th Amendment. The first is Corfield v. Corio, 1825, then confirmed by the full Supreme Court in 1876. The common resources of a state, like its fisheries and public lands, were not understood to be privileges common to the citizens in the several states. These were privileges unique to the citizens of each particular state, so they were understood to be privileges of special rather than general citizenship, as the Supreme Court said. These also sort of the reason to exclude them from comity was resource exhaustion. The state was allowed to ensure the preservation of its natural resources, and that meant it can limit access to them and reserve right to its own citizens. The second set of sources relates to the antebellum systems of poor relief laws. So as I tried to show in the paper, it was widely accepted that a state could remove a pauper who was liable to becoming a public charge to the state of that pauper's legal settlement. The poor relief laws were limited to local citizens, to the citizens who contributed taxes for their support. So poor relief laws, classic public privilege, public benefit, were not covered by Article 4. The third set of sources relates to corporate privileges, which were also public privileges. Numerous state laws reserved the right of incorporation to the state's own citizens, and a state also could refuse to recognize foreign corporations. The cases sounded in similar reasoning. Whether to grant, recognize corporate privileges was a mere matter of municipal regulation. It was not this right or privilege common to the citizens in the several states. It was unique to each state's own law. Okay, so the question then becomes whether the Privileges or Immunities Clause covers public privileges, as it must, if we are to believe that Brown v. Board was correctly decided. And I think the answer is yes, for a number of reasons, although if I may mix admittedly related metaphors, there's no smoking gun, silver bullet evidence for this proposition, but I think it's still right. Okay. They are related metaphors, after all, so let's mix them. Okay, first is the textual difference. The comity clause guarantees equality in the privileges and immunities common to the citizens in the several states. The privileges or immunities clause guarantees all the privileges and immunities of a United States citizen within a state. That would seem to include not only the privileges of general citizenship, but also the privileges of special and local citizenship. Second is, I think, the obvious reason that comity concerns are irrelevant to the Privileges or Immunities Clause. All citizens of a particular state pay for the support of their public privileges and therefore should get to enjoy them equally. Third, again, this whole argument is that the Privileges or Immunities Clause does for intrastate discrimination what the Comity Clause, the Privileges and Immunities Clause did for interstate discrimination. So it basically federalizes what was already the requirement of a variety of state equal privileges or immunities clauses. And as I show in the paper, these were understood to include corporate privileges and other public privileges. So public privileges were understood to be privileges of citizenship under state law, even if not privileges of general citizenship. And then fourth reason is in the debates that would lead to the Civil Rights Act of 1875. All but one of the Republicans who are still there thought that the Privileges or Immunities Clause extended to public privileges and to public schools, largely on the basis of this taxation argument. So perhaps, I guess the point is, public privileges, it is not a civil right common to the citizens in the several states, but perhaps it is a privilege of a citizen of the United States in a particular state. Okay, if I'm right about this, then as noted, I think Loving is an easy case because marriage is not a public privilege, it's not a political right, not a social right, it's a civil right. But Brown is also an easy case because, if I'm right, okay, because public education is a public privilege and is covered by the Privileges or Immunities Clause, even if public education, public privileges were excluded from the Comity Clause. The question then boils down to a merits question, whether separate schools are or are not equal. That again, it's a question on the merits. If you take one thing from this paper today is whatever you think about the merits of that question, it has nothing to do with social rights, whatever those are.